record the presence of the defendant appearing by Zoom.
Thank you.
Ms. Spears representing the defendant appearing in person. Mr. Cody representing the state. Also appearing in person, this is the time set for a status hearing. I have now received both doctor's reports. Have both parties received both of the doctor's reports? Yes.
Yes, Your Honor.
All right. Ms. Spears, from your point of view, what's the status? You want me to set a contested Rule 11 hearing? What's going on?
Your Honor, we just want you to make a decision on the report, and I think Mr. Cody wants a few minutes to argue his point of view. And, I would take the same consideration. And when I say few, he said 5 minutes.
Mr. Cody, is that correct?
Yes, so we're willing to stipulate you can make a decision based purely on those reports, and we could certainly do the oral argument now if the court has time. Neither of us will take a long time, or if the court would rather schedule that out.
You don't mind doing it now? I have notes on the report, but my notes are relatively brief because I wasn't necessarily expecting to make a decision based simply on the reports. Because in the future, if that's what you're going to decide, you can file a stipulation in advance, or just even let my judicial assistant know in advance, and I can have more copious notes prepared in advance of the hearing. So I don't have anything until 11:30. What I would propose doing is taking a break. Again, I read the reports. I'm familiar in broad strokes with what they say, but I would like to take some notes, more detailed notes before I make a decision. So why don't I take like a break? I can review the reports again, make some notes to myself, and then y'all can come out and make arguments. It'll probably take me no more than 5 or 10 minutes to review the reports again because I haven't read them already. Any objection to that, Ms. Sayers?
No, Your Honor.
Mr. Cody?
No, Your Honor, thank you.
All right, we'll take a short break while I review the reports and recess.
Miss Sears, can you hear me?
Yes.
I wasn't able to get any intel on the reports yet from either doctor, and I'm just curious, does this decide the factor of a jury trial or not?
You can, yes. Why are you recording or something?
No, I have 2 phones on speaker.
Oh, okay. That's what.
My other family's here listening on their phone with speaker, and I have it on the other side of the room. But I'm just curious while he's in recess, because I tried to call your office and got the answer machine a little bit ago, and I tried to talk to Erica last week or the other day, and she said she can't talk about the case with me. So I was waiting for you to get back to me and let me know something about these doctors. I was able to comply and go to both of them. And I'm not sure where they stood. So I'm just curious how it would affect me in my life. It's pretty scary for an innocent man. And we're not sure, my family, none of us are sure what this pertains to, or what happens after this, if it continues on a jury trial, or if they both slander my credibility with these false police reports that were made and the false evidence, tampered evidence. If it's just going to make my case stronger or worse against me, it's kind of scary.
You should not be talking in open court, and there's several people online.
Well, they're probably all just, all the people online are my family at different places.
I don't think that that's necessarily true, and the county attorney's here, and the court reporter's here. There's people here that you should not be talking in front of.
Well, if I'm innocent, I'm not as scared to talk. And I'm talking with you because I never seem to get to talk with you all the time. So, and we're in recess, so this is important to us. We kind of want to know kind of what's going on with this because it's kept everybody in limbo. Like, what is their next move? What is this next thing going on? Are we going to have this jury trial? I was supposed to have it a year and a half ago. And all this false evidence should have been thrown out and dismissed. There's been no motions filed for me. We've been trying for 2 years, and they were all rejected, and this is not fair. So it continues on. It just keeps my family and all of us going through it. And you're representing me, so I wanted some intel about what this is about today before he comes back out. That's what we're worried about. It's like he can't make a ruling now and do anything until we are actually go to trial and trying to convict this innocent man, I don't think. We don't get it. So if you don't want me to talk, I won't talk because we're in the court. I get it. But we're kind of scared and we're wondering what he's reviewing again and what he's talking about. A decision on what? Having a trial? I guess you got me muted. I don't know.
You are muted. You are unmuted.
I think they muted me from the other end. She don't want me to talk in the court, even though we're in recess. I don't understand why he wants to go review the reports again and then make a decision on something. What is he making a decision on?
You are muted.
She didn't want me to talk in there. I said, well, all the people on the phones are my family. Right?
Not necessarily.
Who else could be on the phone?
Like what you were doing, listening before your case came up.
But why would the judge want to go review the reports again real quick for 10 minutes? That don't. Before he makes a ruling?
Make additional notes.
I think one doctor said I was okay and one doctor said I wasn't. That's why.
Maybe.
And so now he doesn't know what to do because one's saying yeah, one's saying no. Huh?
I don't know.
Because they'd have to have both doctors saying, oh yeah, he's not correct. He can't represent himself. This is about me trying to represent myself. And they don't want me to because then I get to present all my own evidence. And I don't want her to be my voice and say, well, he's crazy. I get to put in a plea for him. And that's also their trick. No, then we're on mute. I'm like, wait, this shouldn't even be going on, Cameron. My girlfriend Megan already went to court and told him. Two hearings and told him in letters. Dan didn't do nothing. And they still didn't want to let it go. Like Chris said, Mom said, Judy said, everybody said, when Megan get Megan to court, when she tells the judge you didn't do nothing, it's going to be over. They have to dismiss it. And she did, and they still wouldn't let it go.
Right.
How can that be? If you don't have a victim, a witness, a search warrant, no consent, I didn't do nothing wrong. How can this still be going on? Does that make sense? That's what I'm saying.
Did a cone shape.
I want a dozen of them. A dozen donuts. Yeah. She won't let me talk in the courtroom to her because everybody's listening in. And I don't think it matters. I mean, court is about people can be present in a public trial. That's what your speedy trial is about and everything. Mm-hmm. Your right to speedy trial, so it's within 70 to 90 days. So it's public and fair. So people can see that they're being fair. When they have closed hearings and doors, they don't let anybody know what's going on. Then they can be shysters.
Yeah.
You know what I mean? They want to keep me silenced. They don't want me telling the truth. And I want to speak the truth. Only the truth.
You are unmuted.
I said no. No, probably.
Natalie Rose or
Officer, yeah. Maybe Monday the 29th at 10. Just so you know.
You are muted.
table? Or just switch so they can catch it?
I want to catch it. Coral.
They want me to be quiet. You can hear them when they're talking all the time about these cases, but they want me to be quiet when there's people on the phone and hearing about my case because they want to keep it concealed what they've been doing. You get it? But I always want to speak out and tell the truth, even when everybody's listening, when the stenographer's there, so it's recorded. Get it? If they rob you of your First Amendment right, which is your free speech right, they rob you of your Fourth Amendment right, which is no search without a warrant. They rob you of your Sixth Amendment right, which is your speech and trial. They rob you of my Eighth Amendment right. If they rob you of your Fourth Amendment rights, they want to be
Throw
quiet.
that knife in between the speech and then stuff close.
There's the judge again. I didn't hear this.
That's monkey country. That's a old biker game.
They don't want anybody to know what they're doing.
Because
They don't want me to
you did
speak
that
out.
with the
They
pen
hate me.
leg. You know, I don't remember. I think they had a good song.
You should just dismiss it. After Megan spoke in court, they were supposed to dismiss her. Everybody said. That was like 6 months ago.
For a while.
And they won't file a motion and let me file them. I already did. They rejected them.
Yeah, I would just catch it.
They're supposed to be frying innocent people. Trying to make criminals out of innocent people. They're not supposed to do it.
Oh,
I thought we're American.
Did you want to be a carnival thrower?
a thrower, not the receiver.
Well, I don't think either one of these people would like to be on trial for doing nothing wrong but being the hero, would they? Well, I'm laughing about it like them. You know what I'm saying? No.
Oh, I didn't know they had that. There's a couple.
Yeah, I know that.
I can never do that. Even if I sound good.
Is that this one?
I don't think they even do much of the paintball stuff anymore.
Remember I did.
I got all that fishing line, you put a bunch of hooks on it like these guys, and you throw it way out there, it's got like 6 hooks out there, it's all fluid on it. You reel it in after 2 hours, and you get 5 fish hooks. That's how I used to do it all the time. I was doing it like these long lines, the long lines, and making all good. I used them. I used to put like 200 hooks on one, and we'd go with the door, but we'd go out there and we'd drop them, we could reel
But
it
you
in.
just like this laser tag.
Oh, yeah.
That was just from doing that one like this?
I wasn't.
Oh, because you got a cop. Look at catch you.
Now they have the, where they go and walk in,
Oh, yeah.
and get out. My
I've
middle
been
daughter
asking for
said.
3 weeks. You won't even tell us what's going on after this. That's what you want to do. She won't talk to me.
They're smarter than I am.
What's the next thing about?
No.
What do you think? You need to
I don't mind
replace
it.
it. Just holding everything.
And I know you're not really, but
That's why I
that,
have to ask the court. Hey,
I
what's
know.
the job?
Really?
That's what this guy said.
Yeah.
You're supposed to communicate. That's your job. Tell him.
elevator.
It says too bad.
Yeah. Like I said, my daughter was really upset that she was the smartest one in the room. She wanted other people to help.
I didn't yesterday. I might take a little time, so I don't deviate from it.
This is a continuation
You are
of
unmuted.
year 2022, 581, State of Arizona versus Danielle Eric Spellbaum. And Mr. Spellbaum, are you still on the phone?
I'm right here, sir.
For the record, presence of the defendant appearing by Zoom is Sears representing the defendant, Mr. Cody representing the state. I've now reviewed again the reports that were prepared in connection with this case. parties have stipulated the court can make a determination based solely on the reports. And Ms. Sears, any argument?
Your Honor, you have read them. I think the final analysis that both of the doctors do both indicate that having a meaningful conversation is both very hard to do, and also that preparation to have a meaningful trial is probably impossible to do. And based on that, I don't see how the state goes forward. I really don't, and I don't see how the court could have the state go forward. That's really all I have to say, Your Honor. I do agree with what the doctors have said. I have found all of it to be true, if not more so, than what they explained, because I've had a lot more time with it. But that's all, Your Honor. Thank you.
Mr. Cody, any argument?
Yes, so thank you, Your Honor. Regarding, first of all, the state is asking the court to find the defendant competent. Regarding Dr. Harbancik's report, Dr. Harbancik doesn't come to a conclusion. He is not able to because of the defendant's behavior. I think the tie should go to competence, should go to the state. This is not a situation where someone has already been found to be incompetent. We're now restoring the defendant, where the burden would be on the state. We generally assume that people are competent in our criminal justice system. Regarding Dr. Schiff's report, although overall Dr. Schiff finds the defendant to be incompetent, I think there's one sentence or part of one sentence that's particularly illuminating, and that's on the bottom of page 7, top of page 8. While I consider that it is likely that he is an intelligent individual who would be perfectly capable of understanding the proceedings against him should he care to do so. That says it all right there. The defendant is capable of understanding, but he cares not to do so. This is a matter of willingness rather than ability. At the end of the day, I agree the defendant would be very difficult to deal with during a trial. It would be difficult for Ms. Sears or any defense attorney. It would be difficult for the court. We deal with lots of difficult defendants. And the standard is not simply can the defendant assist in his own defense. It's can he assist in his own defense by virtue of the mental disease or defect. And I don't think there's enough of a nexus to show that's why he would be difficult in court. So for all those reasons, the state asked the court to find the defendant competent.
Anything else, Ms. Sears?
No, Your Honor.
All right. Well, with respect to this case, and I guess I do need to maybe start with the burden of proof, because the case law is really very clear that once somebody's been found to be not competent, the burden is on the state at that point in time to prove that the defendant has been restored to competency. I think it's simply by preponderance of the evidence that they've been restored to competency. I don't recall, it's not these situations. I haven't actually looked at the case law recently. But the case law is perhaps not as clear on the initial finding of competency. I tend to agree that there's perhaps a belief or presumption that people are competent until they're found to be not competent. So I believe that the burden is on the defendant So I would tend to agree. I guess I don't necessarily like the tie goes to the runner analogy in the context of legal proceedings. I think it is more apt to phrase it as the burden of proof, and if there is not proved by the appropriate burden, then it would go to the other side, the side that doesn't have the burden of proof. With respect to this case, Dr. Harvancic did not offer a final opinion regarding competency, whether the defendant was competent or not. He did indicate that there is strong evidence that his behavioral issues would have a negative impact on his ability to aid in his defense. Dr. Harvancic says it was unclear whether the defendant had a factual and rational understanding of the charges, the legal procedures. He had a provisional diagnosis of a delusional order persecutory type, but again indicated he was really able to get limited information because the defendant consistently went off on tangents or interrupted him or was ranting against the court. Similarly, Dr. Schiff had an experience with the defendant where it was difficult to get any answers to questions, where the defendant was ranting and going off on tangents and not providing any useful information. Ultimately, Dr. Schiff opined that the defendant had a paranoid personality disorder and real understanding of the proceedings.
That's not true.
Dr. Schiff,
You are muted.
Dr. Schiff opined that the defendant was not competent and it was unclear
You are
if
unmuted.
it was restorable. So at this point, I have one doctor who is opining the defendant's not competent and one doctor who's unclear whether the defendant's competent or not. I would agree that there is a distinction between somebody that makes it difficult to aid in his defense simply because that is his personality versus somebody who is unable to assist in his defense because of a personality disorder or because of a mental disease or defect. So if it is just the way the defendant acts, and as Mr. Cody correctly argued, if it is simply based on this is how the defendant chooses to behave, then it wouldn't be sufficient. If he behaves this way because he has a personality or a mental disease or defect, then it would be a reason to find that he's not competent. And ultimately, Dr. Schiff opined that the defendant was not competent based on the mental disease or defect, and Dr. Harvancic was unable to make a decision. So I don't have any I don't have any mental health expert that is opining that the defendant is competent or has indicated they believe he is competent. When I weigh all the evidence in this case, although I think that it is probably a very close call, and although I think that it is I am not completely convinced that it is a personality defect or, a mental illness or defect or disability. I think that there is sufficient evidence that's been presented for the court to find that. The court finds in this case that restored to competency, that restoration, so the court can either dismiss the charges or order competency restoration unless there is clear and convincing evidence the defendant will not regain competence within 15 months. Dr. Schiff said it was unclear whether or not the defendant could be restored to competency. So I am not finding that there's clear and convincing evidence that the defendant will be. There's going to be too many negatives in that sentence. There is not clear and convincing evidence that the defendant will not be restored to competency within 15 months. In other words, I believe that there is at least the potential for the defendant to be restored to competency. So if the state requests competency restoration, I will order it.
Oh, wow.
This is a defendant that would not cooperate with out of custody competency restoration. So, Mr. Cody, you want me to order a restoration or to input or to do a restoration order, or do you want me to set another hearing where you can decide whether the state's going to pursue restoration in this case?
I think Your Honor, they would just ask the court to set another hearing. It doesn't have to be more than a week out. We're actively considering that question of whether we have the resources for this. We will have a decision by the next hearing.
I will be gone from Friday till I won't be back until April 29th, so I would have to have somebody else cover it. But if it's just for the purposes of restoration, I guess I could call in if that would be okay.
A restoration, huh?
Yeah, I would allow you to call in, Ms. Sears, for the next hearing, and I guess we could see if we could do it if you have the decision made by as early as Friday.
So the doctor slandered me.
But otherwise, I'll do it.
The doctor slandered me.
Mr. Feldman,
You are muted.
hold on. Your attorney will explain to you what's happening.
You are
Once
unmuted.
the hearing is over. You will be here Friday. It's just you're gone after Friday. This year,
Yes.
I could do it at 3:30 on Friday afternoon. No objection.
That's fine, Your Honor.
What day is that? Today's the 2nd, so that must be the 5th.
Yes.
All right, it's ordered.
Can I please ask one question, sir? I really want to speak for myself. I do have the First Amendment right, and this attorney keeps not conversating with me, and the doctors, they came out with an attitude like they were already biased, and so they started directing these questions at me like I was already their subject and like I was already guilty, and so it was very offensive, the questions they were trying to instill on me, and so I was defending myself in their questions because I'm an innocent man. So I really want to be able to represent myself or speak for myself. I have lots of evidence, and if I can't represent myself, I feel that I'm not going to be represented correctly, and I don't appreciate these false charges.
Mr. Feldman, you need to listen to me for a minute.
I am.
I've made it that you're not competent, and if you're not competent to stand trial, although there is a slightly different requirement, there are slightly different findings. I would find at this point in time that you're not competent to represent yourself either. So until you're restored to competency to stand trial, then we would take up the issue of whether you're competent to represent yourself at that point in time.
Does restoring the competency, does that mean putting me into a facility of some sort?
At this point in time,
That's unfair.
because
I'm an innocent man.
cooperative with anybody.
But I've done nothing wrong, and there's no evidence I have. It should have been dismissed. There's no victim, no witness, no search warrant, no consent. You're running on nothing but hearsay and false reports and false evidence, tampered evidence. I've done nothing wrong. I'm not supposed to be ordered to be doing anything. This is...
Mr. Court, setting this case for status hearing on April the 5th at 3:30.
April the 5th?
Sir,
No, Your Honor, thank you.
Mr. Cody. No, Your Honor.
There-
Order affirming prior conditions.
Sir, what about the attorney change? I want an attorney that's going to represent me fairly and speak with me and communicate, not someone that's already biased and on the payroll that's doing the opposite of what we've been asking. We need to be represented. Huh? Yes.
If you want to restore competency, then we will talk about what attorney is going to represent you at that point in time.
You're trying to you're telling me you're going to put me in a facility and I've done nothing wrong to restore me to what some guy said and slandered me, making stuff up. That's not fair. You're supposed to give me a fair chance and a fair trial and a fair chance to present my evidence and show that I'm innocent, not just keep putting me and forcing me to go through this, is what I'm saying. And this attorney is misrepresenting me. And I have conflict with this county. So I need to get it moved to where I can have...
Mr. Jones, at 3:30 on Friday.
You are muted.
At that point in time, we'll stand at recess.
Oh,
You are
oh my
unmuted.
gosh. I can't believe this.